जय हिंद व्ह्युअर्स. तर आजपासून पॉलिटी सुरू केलेलं आहे. तर आणि जे इथिक्सचा प्लॅन आहे ते रेग्युलर थोडा थोडा चालू राहणार आहे, जसं की आज 2 ते 4 मध्ये आन्सर रायटिंग केलेलं आहे है ना. आणि आजपासून क्वालिटीचं एक नवीन सेशन म्हणजे क्वालिटी आजपासून सुरू होणार आहे. ठीक आहे, तर ते आपण डिस्कस करू आता. तर सगळ्यात पहिले की व्हॉट इज कॉन्स्टिट्यूशन. कॉन्स्टिट्यूशन काय की सिम्पलिस्टिक आन्सर would seems like it is a body of laws, but not all are found in the Constitution. Right to Information Act, Consumer Dispute Act, National Human Rights Act, etc. are the laws that are found outside of the Constitution. ठीक है. Constitution का ये fundamental law, fundamental law of the land. ठीक है. So so uh, how is the law that is framed by the state legislature and the parliament different from the laws found in the Constitution? If the Constitution is the body of laws, such laws outside of the constitutions are termed as the statutory laws. जे पण laws हे कॉन्स्टिट्यूशनच्या बाहेर आहे, लॉ आउटसाइड द कॉन्स्टिट्यूशन आर टर्म ॲज अ स्टॅट्युटरी लॉज. ठीक आहे. While the ones contained in the constitutions are known as the constitutional law. The constitutional law, while being the part of the constitution, are the part of the fundamental laws. Okay, fundamental laws, and hence it is a more difficult to change, amend, and remove them as compared to the statutory law. तर हे फंडामेंटल लॉ असल्यामुळे यांना चेंज करणं, याला अमेंड करणं, याला रिमूव्ह करणं हे थोडंसं डिफिकल्ट आहे. ठीक आहे, हे डिफरन्स वाला पॉईंट आहे. द युनियन पार्लिमेंट इज द क्रिएशन द युनियन पार्लिमेंट इज द क्रिएशन of the constitution and hence cannot legislate law that violate the principal law of constitution itself. Hence we can deduce that the law mentioned in the constitution is something like a supreme law. Union parliament is the creation of constitution, hence it cannot legislate the law that violate the principle of the law of constitution itself. Thus the legislative power of the parliament to make the law cannot violate the supreme law that deals with the fundamental of the existence of the society. जरी legislative power of the parliament जे आहे ते fundamental law ला violate नाही करू शकत. ठीक आहे, of the existence of the society, and the supreme law is termed as the constitution. So the constitution can be the fundamental law or the fundamental set of the principles according to which politically organized society is governed. हे त्याची definition. ठीक आहे. Hence the constitution can also be succinctly described as the law of the laws. ठीक है. Many colonized countries around the world, they gained the independence from the colonizer, and the first task they got involved in war when the constitution was adopted. ठीक है. The constitutional law versus the statutory law. The constitution is a set of the fundamental laws. Due to its fundamental character and nature, it enjoys a superior position vis-a-vis the statutory law as compared to in relation to the statute. Vis-a-vis का मतलब क्या है? In relation to. ठीक है. This can be seen in the procedure required to change the provisions of this law. The more the importance of the law or provision, the more is the difficult to amend it. The constitutional law, while being the part of the constitution, is a part of the fundamental laws, and hence it is more difficult to change or amend or remove than them as compared to the statutory law. The statutory law जो है कि easier to amend है, not a fundamental. Constitutional law की superior है, fundamental है, and difficult to amend. Difficult to amend. ठीक है. The constitutional law. Constitutional law का है termed as the entire body of laws. Although there is nothing wrong with the definition, it is a slightly a wider term because the constitutional law go beyond what is mentioned in the constitution. It includes whatever uh, is there in the constitution, subsequent amendments, interpretation of the Supreme Court. अच्छा, constitutional law मध्ये ह्या पण सगळ्या गोष्टी आहेत की constitution मध्ये काय amendment झालेल्या नंतर interpretation of the Supreme Court in the various cases before the court and the convention that have evolved over the time. Even though the convention hasn't been codified, it still has the force of law. For example, the fact that the leader of majority party is invited for the formation of the government is not codified in the constitution, but it is still followed due to uh, due to it being a convention. In the case of the governor, in case of governor, Sarkaria Commission suggested the appointment of the person from the another state, then the state is being appointed. This is the convention that is usually followed. समजा एखाद्या कन्व्हेन्शनचं उदाहरण घेतो कन्व्हेन्शनचं काही क्वेश्चन आलेलं तुम्हाला एखादं कन्व्हेन्शन आहे फॉर एक्झाम्पल सरकार या कमिशन काय रिकमेंड करेल की गव्हर्नर इज फ्रॉम द अनदर स्टेट है ना गव्हर्नर जे पाहिजे आपल्याला पर्सन फ्रॉम द अनदर स्टेट that the state is being appointed to. Significance काय ठीक आहे हे मेन वाला पार्ट this act after the birth of the nation is the framing constitution as it set up the common set of norms or the common normative home हे शुद्ध कामाचं आहे common normative home through which the diverse element of the society interact harmoniously with each other. Common normative home say through which the diverse element of the society interact harmoniously with the nature. What a birth certificate to the child is the constitution to the nation. It is given the basic structure of the polity and the system of the governance. Basic structure लिहिलं ठीक आहे नंतर details the pattern of the relationship between the legislature, executive and the judiciary. ठीक आहे नंतर त्याच्यानंतर the constitution also details the relationship between the state and the citizens and its constituent citizens. ठीक है it also deals with the ideals and aspiration of the people but along with it the conflict as a visible throughout the constitution particularly in the framework ideals and aspiration of the people ठीक है the constitution also acts as a mirror of the society and it's alleged the fault within our society and tries to address them or if these the fault were not addressed they would tantamount to the perpetuation of injustice. For example, the language, caste discrimination, injustice against the woman, minorities, both the linguistics and religious. The constitution gives the legitimacy to the state and its action. For example, the taxation. Here should be a point on that. In a democratic nation, the government cannot be absolute, and hence there are legally enforceable limitations on the government to prevent the execution. You know, democratic nation में चांगले the government cannot be absolutist and hence there is a legal enforceable limitations on the government to prevent absolutely. Hence the constitution is only the place where the legally enforceable limitation can be placed on the state authority. तर हे सगळ्यात महत्त्वाचं आपल्याला नंतर कॉन्स्टिट्युशनलिझम काय आहे की इट इज द कॉम्प्लेक्स सेट ऑफ आयडियाज कॉन्स्टिट्युशनल कॉम्प्लेक्स सेट ऑफ आयडियाज that is based on the principle of the principle that the power of the government are not absolute and are limited by the bodies of laws and supreme law is called the jurisdiction. Limited. The government's power is not absolute; they are limited by the government has separate to the body of law for its legitimacy, depending on it. Because the government has to separate to the body of law for its legitimacy. ठीक आहे कंपोनंट काय काय त्यांचे कॉन्स्टिट्युशनलिझमचे कंपोनंट रूल ऑफ लॉ रूल ऑफ लॉ मध्ये पण भरपूर गोष्टी येतात आणि आर्बिट्रेशन नाही लिहिलं मी त्यात although the many people have contributed to the principle of the rule of law principle is the dicey heavy dicey contribution has been more similar the rule of law has many components but basically it is means to rule by law it has many components namely okay, supremacy of law arbitrary exercise of the power is prohibited and equality before the country will be ruled not according to the whims and fancies of the ruler but in terms of the principle of the law and the ruler is also acceptable. Principle of the also say that you will ever be so high, but the law is above you. king of the king. Brahma is the king of the kings. Even the Upanishad similarly, Rex is a Rex. Rex is a Rex. 11 ठीक है. The natural corollary of this postulate will be that the rule of the country has to be accordance with the law and hence cannot be arbitrary. And the rule of the country has been accordance with the laws and cannot be arbitrary. The arbitrariness exercise of the power is fulfilled. Equality people. The Dyson said that all the sections of the society are equally subject to the law. All the sections of the society are equally subject to the law of the land as administered through the ordinary code. Though in modern practices, the state relates to the affirmative actions for positive discrimination, while the strict application substantive equality versus the while the strict applications of the principle but are in the tune with the modern times. म्हणजे काय की substantive equality versus the procedural equality. The equality of the laws administered the ordinary code. But today we have many forums that have the adjudicatory and judicatory functions other than the ordinary courts, said by the examining the constitution of quasi-judicial forums like the CAT, IDAT, tribunals, etc. Equality of the law, administrative of the ordinary code. Here are the certain exceptions to legal equality. Exceptions कोणते कोणते ते बघू. In Indian Constitution, while the President and the Governor are in office, no criminal proceeding the exception है कि President and Governor are in office, no criminal proceedings can be started against them as per the Article 360. ठीक है. And no civil dispute can be undertaken unless the 2 month notice. Civil dispute पण क्या रहता है unless the 2 month notice. Violations of formal equality. A.G. Nurani termed the criminal exemption to be the mindless borrowing from the West. Mindless borrowing from the West based on the British practices where the courts cannot prosecute the law. In Britain, the courts are the creations of the crown and hence cannot prosecute. Courts are the creation of the crown. Crown ने स्वतः बनवलेला असायचे. Therefore, it cannot prosecute. But in India, both the president, Britain मध्ये बघितलं त्यांचे courts a creation of the crown and cannot prosecute. But in India, both the president and the courts are the creation of constitution. And hence the similar provisions are weak. Nurani also termed that these provisions can be abused, where the politician facing the criminal prosecution can be appointed as a governor. आहे त्याचा दुरुपयोग झालेला आहे. नोरानीने सांगितलं की जे politicians facing the criminal prosecution can be appointed as a governor, for example, as a deputy. Nurani also said that hypothetically, if the provisions is not there and no criminal immunity was present and such provisions was enabled through the constitutional amendment, such move would not get the approval from the public of the purpose. The similar exceptions is the concept of diplomatic immunity. Exceptions आहे दुसरं सगळ्यात पहिले exception आहे दुसरं आहे की concept of diplomatic immunity. Violate formal equality in the provisions of the section 499 of the IPC. The contempt of the court is present, but any legislation, while speaking on the floor of the House, is exempted from these laws and constitute the parliamentary privileges. हे तिसरं parliamentary privileges वाला तिसरं. नंतर काय concept of diplomatic immunity. ठीक आहे. तेवढं होतं सेपरेशन ऑफ पॉवर झाल्यानंतर बघायचं दोन गोष्टी बघितल्या आपण आणि रूल ऑफ लॉ वाले बघितलं आणि इम्पॉर्टन्स ऑफ कॉन्स्टिट्यूशन बघितलं. आता हे काय होतं की आपल्याला बघायचं इथं chapter of 18 the वाचू गई म्हणजे इथं सांगितलंच नाही तर Nature of constitutionalism. ठीक है, rule of law, separation of power, rights of the people, democracy, free media, independent judiciary, ये सब है. Negative and positive constitutionalism. Negative constitutionalism का है कि preventing the tyranny, जुल्म prevent करा. ठीक है. The idea that the state can be danger of the source of oppression to the city. Negative concept has gained the ground in the late medieval and early modern age. Consequently, the idea of negative constitutionalism developed largely among the Western thinkers in the efforts to prevent the tyranny by limiting the powers of the government. Limiting the power of the government to prevent the tyranny or the source of oppression to the citizens. Positive constitutionalism by an obsession or the zeal of limiting the powers of the government may lead to the situation where the states is hindered from the basic public good, resulting in anarchy and factor affecting the uh, factor affecting the constitutionalism. Like these principles have been assimilated in the Indian constitution to the various states. It is important to note that the mere codification of the principles in the constitution is not the sufficient conditions for the presence of constitutionalism in the country. Further, these principles have to be implemented and observable to the citizens daily to conclude by the presence of the constitution. In fact, the case UK, the presence of unwritten constitution doesn't prevent the country do not have a constitutional law. Thus, we conclude that the mere presence of or absence of codification of this principle does not guarantee the presence or absence of constitutionalism. The codification जरी असलं तर constitutionalism हे सांगू शकत नाही. ठीक आहे. The realization of the principle of the constitution depends on the following factor. बरोबर. आता एक political factor. The institution is more responsible for nurturing and strengthening the tradition of democracy are the political parties. But in India, the political parties are the danes of undemocratic culture, with many parties even functioning as a family fiefdom. हे सांगितलं नाही कोण आपल्याला. Interpretation of the constitution विचारलेलं आहे. Interpretation मी वाचू शकतो. ठीक आहे. Our constitution has to be applied correctly, and hence, even though it is a voluminous document, it is to be interpreted in the right manner. The tools that have aided in the interpretation of constitution. कोणते कोणते tools? Article 366, 367, and 12. There are the rules in the constitution itself to interpret the constitution. Constitution schedule. For example, Article 366 of the constitution contains the definitions of many terms. They are used in the constitution. An example being the provision where the scheduled caste, tribe, Anglo-Indians are defined. For example काय की शेड्यूल कास्ट काय आहे, ट्राईब्स काय, अँग्लो इंडियन्स काय, तिथे ते डिफाईन केलेलं आहे कॉन्स्टिट्यूशन. ठीक आहे. दुसरं की आर्टिकल नंबर 12. Article 12 defines the states as used under the many provision in the constitution. In 1987, the British enacted a law, namely the General Laws Act, which consisted of a list of legal terms defined under the act. This act has been General Laws Act 1897. याच्यामध्ये काही भरपूर टर्म्स मेन्शन केलेले आहे इन द इंटरप्रिटेशन ऑफ द कॉन्स्टिट्यूशन. English word, the Supreme Court has written a number of the rulings to interpret the Constitution. Republic commonly used many words under the context demand amendments. त्यानंतर preamble मध्ये दिलेलं आहे की preparation of the Constitution or the application of the philosophy of Constitution. The philosophy of the Constitution which has been multiple interpretations are made, but still that particular interpretation is still correct. It's no recognition. Since norms in the society do not remain static all the time. According to change, rules how do it wise to interpret the provisions. The Constitution must reflect interpretation to establish recollect these terms and did not make the quantitative aspects which we talked about. There is some interpretation of identity, but this is communication like animal existence as a definition of performance responsive definition of as interpreted in Article 20 value the quality of this side of many by condition but conjugate representation this method of calculation purpose topics non-Boolean expression theory. In interpretation of features in non-Boolean expression, but the interpretation should be done in the interpretation topics to hold the part of the interpretation organized potential interpretation of subjective manipulation is actually document that is put and interpretations should be reconsider the articles given the liberal interpretation. Interpreting of the provision of article particularly considering the liberty of security, justice, and equality. The liberal rationale agrees that the purpose of justice and the structure of the external privacy media information has been put different freedom of speech and 1911 materiality liberal interpretation of justice is on the two used by the judiciary with the constitutions. So some convention, if not all, followed under the parliamentary system in India. It was